There was a very important status conference in the Alex Murdaugh case today. This is the status conference that is preceding the evidentiary hearing, which is going to occur at the end of January. So buckle your seatbelts for that. And the good news is that the evidentiary hearing will be open to the public. That's what the judge ruled today. It will be an open court. Even the jurors' testimony will be in open court. You're not going to be able to see the jurors, but there should be audio and there's going to be press allowed. So that is going to be great. I think everyone's very happy about that. They'll be able to hear everything that goes on during that hearing. So good news over there on that front. But in that status conference, also the judge allowed argument for some of the issues that we were actually discussing up until now. So if you've been a viewer and follower and subscriber of this channel, if you're not, you definitely should be at this point. So please do that right now before we go on. Then you were able to sit there and watch and understand everything that was going on, and everything just clicked in your mind, and you were able to understand the legal analysis that was being done. You understood the arguments, and you probably also came to a conclusion about what the judge should rule about specific issues. And we're going to jump into that in just one second. But first, I want to give you a little bit of an overview about some of the important things that happened, and then we're going to jump into the meat of what happened during this hearing and what I think was a very big mistake that the judge made in this case. So let's just first give you an overview about what happened. So the judge said she has certain bullet points that she wants to go through during the status conference to prepare for the evidentiary hearing. Number one, she said, is an evidentiary hearing even necessary? And it's interesting that she's bringing it up because she already scheduled the evidentiary hearing and there's already been briefing about whether there should be an evidentiary hearing, yet she is still allowing argument about whether there should be evidentiary hearings. So why is she doing that? Maybe perhaps to give the opportunity for the state to make a record, even though everything's preserved by the motions that they filed and the briefing that they filed with the court. But here's to cross your T's and dot your I's. Here's the opportunity to make a record. So the state did make a record why they feel that there should be no evidentiary hearing, and the defense argued that why there should be an evidentiary hearing. Like I said from the beginning, months ago, that of course I believe that there should be an evidentiary hearing, given what I've seen, the affidavits, etc., and the case law. So an evidentiary hearing is going to happen. Number two, she discussed what's the burden of proof, and she let each side argue about that. And we discussed that in our filings. We discussed it in our last video about which was included in the filings that the defendant filed and what the state filed, and we went through some of that, and we're going to jump into that, get a little bit more of a deep dive in a minute. But that was also another avenue which she opened up, the burden of proof. Now, what's something that you may have noticed, certainly if you're a follower of this channel, and we've discussed this in the last video, that was not discussed during the status conference, which probably should have been discussed, was that there was no question about what burden do they have to prove? What standard do they have to prove this case by? Do they have to prove this case beyond a reasonable doubt? Do they have to prove that there was jury tampering by the preponderance of the evidence? That wasn't even discussed, and we discussed that in our last video. You can go check that out. So I thought that was interesting that that was not discussed. They were more discussing about who has the burden to prove what, and if there's any presumptions of prejudice, which we're going to get into in a little bit later in the video about all that, and we're going to explain it and break it down. But let's move on a little bit just to continue the overview. Then she also discussed about what should the procedure be in terms of calling witnesses. Who should we call and who should be asking the questions? And essentially what the judge said is that she's going to ask the questions to the jurors, and the jurors are all going to be called. They're all going to be subpoenaed. And essentially she's going to be asking two questions as it stands now. Of course, each side can continue to file things, which they will, and suggest additional questions or possible additional questions that she can consider asking. But the two essential questions which she is prepared to ask each juror is, number one, was there improper contact made with Becky Hill? And number two is, did that affect your verdict? And we're going to get into that, a second question, which is very important, also coming back to that. Then when she discussed about whether Ms. Hill is going to take the stand and what could be asked of her, what avenues can be explored on cross-examination. She said she's not going to just open up her whole entire career for the defense to ask cross-examination questions about her character and allegations of deceit and things like that. So she's not going to just allow this just completely to go as far as they want. It's going to be much more restrictive and much more narrowed about specifically what happened in this case. So that was also another thing that she pointed out. Another thing that she said is that alternate jurors are not going to be asked questions, which is a very important issue for the defense, because we all know famous egg lady juror who did not participate in the deliberations, she very clearly said in her affidavit about what happened, and that she heard and witnessed certain tampering by Becky Hill. So that is also going to, that's the defense made a big stink about that, because they want this alternate juror to be asked questions, and they feel that it helps their credibility of that side, because you're corroborating with the other jurors with what they heard. So if you're going to have a bunch of jurors saying they didn't hear anything, and you have 2 jurors that say they did, well, it will corroborate that side. So that's why they feel that she should be able to be asked questions. And the judge says, well, as it stands right now, she's not going to, and they have to file they have to file some more papers, another affidavits, laying out more, perhaps, and then maybe she'll change her mind. But also an interesting ruling, I thought that the alternate juror should be asked, because certainly it does help with the credibility of the other jurors. So that's essentially the overview. Now, yeah, I discussed that. Okay, so now let's get into some of the case law which they argued about, and some of the rulings that the judge made, which I think, in my opinion, were mistaken. And again, like I always say, I don't have a dog in this fight. I'm not trying to side with one side over the other. I'm just telling you, I'm a searcher. I look for the truth. I seek the truth. And when I look at the case law and I analyze the case law with my understanding and apply it to the facts, sometimes I may come out on one side over the other. But that's not because I'm biased to one side. I'm just telling you what I see from the case law. And of course, at any time, anyone can look up these cases themselves and tell me that maybe I made a mistake and show me where and how I made that mistake, and that's fine. But we're going to jump into this. So the first thing that I want to discuss is the State versus Cameron case. The State versus Cameron case, which I discussed in my last video, and I said very clearly that I don't believe the State versus Cameron case got it right. I just don't think that. And if I was on the defense's side, I wouldn't even argue for their position, because it's almost so clearly wrong for it to rely on State versus Cameron. And this is where a lot of attorneys sometimes make a big mistake, because they go for the home run. They want the home run, and therefore they don't argue the winnable position. They argue the position that would just win the entire case for them. And then when they strike out, now they're left with nothing. So that's essentially what happened here, because they argued, the Murdaugh's team, defense team, argued State versus Cameron. And just to remind you about what State versus Cameron says, State versus Cameron says the following: when there has been such a communication, meaning a communication between a court official and a juror, a new trial must be granted unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. So if it's not clear that the communication was harmless, if it was about the merits of the case, then automatically you get a new trial. And this was one of the arguments that the Murdaugh team made, was that, well, it's clear as soon as one juror says that there's been a communication between a court official like Becky Hill and a juror, then right away that should be the end of the evidentiary hearing, new trial granted. And that's what they're going for. They're going for the home run. And I said in my last video, if you follow the law from the beginning, this case is wrong. State versus Cameron is just wrong. And they obviously didn't listen to me, and they made that mistake. And the judge right away shot down and said, no, we're not going to go with State versus Cameron. And we're going to play a clip from her very soon to show you what she felt about some of these cases. But that was one of the things that as soon as you were sitting there and you were watching, if you were a viewer of my channel and you were saying, oh no, they're arguing State versus Cameron, you know exactly how this is going to end. Well, you were right, because you got to listen to brother counsel if you want to win. So that was the first mistake that they made. They argued State versus Cameron. And the other argument, remember, was that the defense is arguing that there's a prejudicial, if you don't go with State versus Cameron, then they're left with basically Remmer. And they were arguing that we need a Remmer hearing. And what you're left with Remmer is, Remmer says that if there's been a communication, which we're going to jump into a little bit more straight out from the case law in a second, but if there's been any communication between a third party and a juror, then there's a presumption that that conversation was prejudicial, and now the burden shifts to the state. The state has to prove that that conversation was harmless, that contact was harmless. That's what Remmer stands for. And we discussed in last video that, on the Murdaugh case, of course, that Smith versus Phillips does not say that. Smith versus Phillips says that the defendant has to prove that not only was there a communication between an outside party and a juror, but also that that communication biased the juror. They have to prove actual bias, and that obviously conflicts with Remmer. And I explained to you in the last video that if it was me making this argument, whether I was on the Murdaugh team or whether I was on the state's team, I would make the same argument. The argument would be, I mean, not the same, but it would look the same. The same would be like this. It would be, Your Honor, we've got Remmer. Remmer says very clearly that there's a presumption of prejudice if there's been any communication at all, and that you don't have to prove bias. That's very clearly stated in Remmer. We have the Smith versus Phillips case, which contradicts that. What should South Carolina do? Well, Your Honor, I believe, and if I was on the Murdaugh team, I would say, well, Your Honor, I believe that South Carolina should follow Remmer. And if I was on the state side, I would say, although we have this contradiction, Your Honor, I feel that we should follow Smith, this South Carolina should follow Smith versus Phillips. And that's how I would approach it. And then I could use some of the what the other jurisdictions have done. What have the other circuits done? What have the other states done with this conundrum, with this contradiction between Remmer and State versus Phillips? Instead, both sides didn't listen to me because they obviously don't want to be good litigators. And what they decided to do is they tried to distinguish. Now, of course, we do learn in law school, and this is something that we practice with all the time as a lawyer. You have to distinguish between certain opinions that are not favorable to you. So if you have a factual scenario and then the other side has a case which has a holding which is not favorable to your factual scenario, what you have to try to do as a lawyer is you have to try to show, well, those facts are a little bit different than our facts, and that's why that case perhaps would not apply to this factual scenario. It would only apply to that factual scenario. And this is like the default. This is like the knee-jerk reaction of a lawyer, is to right away try to think about how that case is a little bit distinguishable from the facts that you have in your case. And a lot of times we have to do that, and that's fine. And I do that a lot. But when you have a very clear contradiction between two cases, and then you start to try to play this game, it's not going to end well. And both sides do this. The state does this because the state just kind of tries to ignore Remmer a little bit, and they try to just say State versus Phillips, and Remmer's a little bit different, but State versus Phillips, they don't really address the contradiction head on. And then the state and then the Murdaugh team does the same thing. They try to start distinguishing all the cases that follow Smith versus Phillips and saying how it's factually different than the case of a court clerk tampering with a jury. Instead of saying, we understand that there's Smith versus Phillips, but we think that you should follow Remmer versus United States. It's a very clear contradiction, and this is why you should follow Remmer versus United States. But they don't do that. And then if you were watching this status conference play out, then you saw exactly what happened when you don't follow the advice of brother counsel. And what happened here is that the defense team from Murdaugh started arguing that all of those cases that the state mentioned are distinguishable because that had to do with the juror's own bias. That has nothing to do with a third party trying to bias a defendant, a juror. When a third party is trying to bias a juror, then that's when you apply Remmer. But maybe you can apply those other State versus Phillips types of analysis when you're dealing with the juror's own bias. And that's how they try to distinguish the two. And yet, you saw right away how they looked a little silly because the state right away responded, what are you talking about? These are all outside influences. There's a pamphlet, which is an outside influence. One of the cases was an alternate juror. One of the cases was a bailiff. One of the cases was a bartender. One of the cases was a pastor. So you're trying to distinguish something, and quite frankly, it's not distinguishable. So they looked a little foolish, in my opinion, because they didn't follow my advice. Okay, so that was just another thing that I noticed during this hearing. But now let's jump into why I think the judge made a terrible mistake here, and which is why I'm not trying to disparage anybody here, obviously. I just think that she made a mistake in how to interpret these cases. And the reason why this is so significant is because now, if a new trial is not granted and this gets appealed, we may have to do this all over again because the wrong standard was applied or the wrong burden of proof was applied. So first, let me play for you the clip of what she said and what I take issue with.
Here's my position on the matter. First of all, this is not I am not conducting a Radner hearing. Radner is a 1954 decision of the United States Supreme Court that deals with the question of influence of the jury and a motion for a new trial on the basis of after discovered evidence of that influence. I rely on the South Carolina decision of our Supreme Court authored by Justice Kittredge, State versus Green. And the Green decision specifically says that Radner is not the guidance that South Carolina trial judges should look to in conducting hearings on after discovered evidence. I do not regard State versus Cameron as the guidance that needs to be used by me in making a determination about this case. It's a Court of Appeals case. Since that case in 1993, there have been several cases, including Green, Oliver, and others, that very specifically talk about this issue of what the burden is when a motion for a new trial on the basis for after discovered evidence that involves tampering or alleged tampering with the jury. All those cases say that prejudice must be proved, not presumed. And it may very well be that that is what's going to be shown. But for purposes of what the defendant must show as the case goes forward to an evidentiary hearing, the presumption simply by the contact, which we don't have any sworn evidence about except in the area of one juror at this time. A presumption is not the way to examine this issue, but rather specific evidence about what was said, when it was said, and how it was perceived by the juror is what I believe is required by State versus Green and other cases. And therefore, that is the approach I will take.
So the first thing that she said is that she's not going to rely on Radner. She's not relying on Radner. Because Radner, after all, was a 1954 case, and it was a federal case. Remember, there's two separate tracks here, right? There's two different systems. There's the state system, and then there's the federal system. Alex Murdaugh's case was in the state system. This is in the state system. So in the state system, you have to use state case law. And in the federal system, you use federal case law. So this Radner decision was a federal case. So therefore, she says, I'm not even going to follow Radner because it has nothing to do with the state of South Carolina. I'm going to follow, and she says very proudly, I'm going to follow South Carolina jurisprudence, which is the state of South Carolina jurisprudence, and I'm just going to essentially ignore Radner. That's the first thing that she said. And then she said that obviously she's not going to go with State versus Cameron, which I kind of told you was obvious. But then she says that she's going to go with State versus Green, and then she says that State versus Green says specifically that prejudice has to be proved by the defendant, and it's not presumed like Radner. Radner says it's presumed. No, State versus Green clearly says, and she also says another case, I think Oliver, which I couldn't find, but I know State versus Green. So she says State versus Green says specifically, and this is what she said, that prejudice has to be proven. That is the burden. So the burden is on the defendant. This is her ruling. The burden is on the defendant to prove prejudice. So essentially prove bias. Essentially she's following Smith versus Phillips and not Radner. Okay. Now, why do I think that that's a mistake? Well, it's not me. I'm just looking at State versus Green. And anybody who wants can go and pull this case, State versus Green. Now, there's two different opinions here. One's from the Court of Appeals of South Carolina, and one is from the Supreme Court of South Carolina. And they're both important. So first, the South Carolina Court of Appeals got this case. And remember, this was a case where the jury asked the bailiff what would happen, or one of the jurors asked the bailiff what would happen if we're deadlocked, and the bailiff said, well, the judge would probably give you an Allen instruction. Right? An Allen instruction basically just says, keep at it, guys. You're doing a good job. Be open-minded. Try to discuss things. Try to meet somewhere in the middle, and just keep deliberating. So that was the Allen instruction, and the bailiff took it upon himself to tell the juror that that's what the judge would do. So the defense filed a motion that they should have a new trial because of this inappropriate communication between the bailiff and the juror. So this is what the Court of Appeals, this is the Court of Appeals of South Carolina. So this is a South Carolina jurisprudence. This is what they said about the Radner decision. In the event the trial court learns of an allegedly improper contact with a juror, the procedure of Radner versus United States must be followed. So this is not just a federal case, and you're trying to pull a federal case into the state system. This is a state case. This is the state of South Carolina, their Court of Appeals, which they're saying that we are telling you, everybody in the state of South Carolina, we're telling you that the procedure of Radner versus United States not can be followed, must be followed. So they are adopting Radner versus United States into the jurisprudence of South Carolina. So right off the bat, if you just read the Court of Appeals opinion, you would say that this judge just made a mistake. Because it's not just a federal case. This is a federal case that was adopted into the state jurisprudence, the state of South Carolina's jurisprudence. And then they quote the case, which says the following. This is what Radner says. In a criminal case, any private communication, contact, or tampering directly or indirectly with a juror during a trial about the matter pending before the jury is, for obvious reasons, deemed presumptively prejudicial, if not made in pursuance of known rules of the court and the instructions and directions of the court made during the trial with full knowledge of the parties. The presumption is not conclusive. So there is a presumption that is prejudice, but they say the presumption is not conclusive, but the burden rests heavily upon the government to establish, after notice to and hearing of the defendant, that such contact with the juror was harmless to the defendant. So there you go, straight out from Radner. It's very clear that if there's any contact, any private communication between a third party and a juror, then there is a presumption of prejudice, and now the burden rests on the state to prove that that communication was harmless. And then they continue. Listen to this. The scope and currency of the Radner presumption has split the federal circuits. So the federal circuits now are split about whether Radner should be followed. But listen what it says. But it remains alive and well in the Fourth Circuit. And you know what's in the Fourth Circuit? South Carolina. South Carolina is in the Fourth Circuit. So in the Fourth Circuit, they still apply the Radner standard, which is that if there's been a communication with a third party, then it's presumptively prejudicial, and now the burden, and that's all the defendant has to prove, and then the burden shifts to the state to prove that it was harmless. And listen to what they say. Now this is the Court of Appeals of South Carolina stating this, and therefore controls our approach to the Sixth Amendment issue Green raises. So they're grabbing hold of Radner. They're inserting Radner into South Carolina jurisprudence very clearly. And then they say when there's evidence of a substantive communication by a third party with a juror, the Radner presumption applies, shifting the burden to the state to prove there is no reasonable possibility the improper communication influenced the verdict. So very clearly in the Court of Appeals. Now, the Court of Appeals, this is essentially what they held. Okay, just follow me for a second. If you follow me, everything's going to be clear. The Court of Appeals felt that when you have the bailiff who said that we're going to give an Allen instruction, and he explained that to the jurors, even though he shouldn't have, even though it was inappropriate, they said that created the Radner presumption. So that created the presumption that now that communication was prejudicial, and now the burden is on the state to prove that it was harmless. And now listen to how the court continues. Mindful the bailiff's official character carries great weight with the jury, we find the comments here triggered Radner. So the comments here trigger Radner. Again, it was a communication with a third party a court official, and therefore right away Remmer will say, well, we have to assume there's a presumption that it was prejudicial. So they say, yes, we're going to assume that it's prejudicial. Green claims the comments irreparably tainted the jury because the bailiff in effect delivered a defective Allen charge outside the courtroom, which coerced the jury into agreeing to a verdict to avoid forced deliberations. And then they continue. While Remmer requires us to presume the bailiff's blunder prejudiced Green, we conclude the state overthrew the presumption by proving there was no reasonable possibility the comments influenced the verdict. So the Court of Appeals essentially is saying here, we apply Remmer. Remmer is good law in South Carolina. We're completely adopting it. Even though other circuits don't go with Remmer, and they go with, we know, Smith versus Phillips, but the Fourth Circuit does, which includes South Carolina, and now as a state, we're adopting Remmer versus United States. We're adopting the Remmer standard, and Remmer does apply here, so there's a presumption, but the state overthrew that presumption as is allowed under Remmer, right? Under Remmer, if the state proves that that communication was harmless, so then there's no error here, and we don't do a new trial. So that's what the Court of Appeals held in State versus Green. Then it got appealed to the Supreme Court, the South Carolina Supreme Court. Now, if this judge is right, that we don't care about Remmer, and Remmer's wrong, then what should the South Carolina Supreme Court say in its decision? What should it say? All it should say is, you guys in the Court of Appeals have got it all wrong. We don't follow Remmer. In fact, we follow Smith versus Phillips. Or don't say Smith versus Phillips if you don't want to say the case. Just say that you have to prove actual bias, which is what this judge actually said. This judge said that State versus Green specifically says that the prejudice has to be proven, and it's not presumed. It has to be proven, and the burden is on the defense. That is what the judge said. And I just played it for you. That's what the judge said. State versus Green, she said, specifically says that. Now, go ahead, look through the opinion, it's not that long, and tell me where it says that. Because it doesn't. It doesn't say that. And in fact, just the opposite is true. If you want to rely on State versus Green, which this judge specifically said she's doing, if you're relying on State versus Green even at the Supreme Court level adopts Remmer versus United States. It does. It just does. But their distinction is a little bit different. What they tell the Court of Appeals is the following. They tell the Court of Appeals the following. We do wish, however, to clarify the Court of Appeals analysis concerning the bailiff's misconduct issue. We just want to clarify something. And this is what they clarify. Okay, they go through the Remmer presumption, and then they say the following. Our Court of Appeals found the comments by the bailiff here triggered Remmer. We are not persuaded that the Remmer presumption of prejudice applied here. They're just saying that the presumption doesn't always apply. They're not saying that throw Remmer in the garbage and that this whole presumption business is a bunch of baloney and the defendant has to prove actual bias. No, they're just saying in this factual scenario, it doesn't apply. But in other factual scenarios, by inference, it would apply. They're not saying throw Remmer out. They're just saying in this factual scenario, it doesn't apply. And this is what they say. Our unwillingness to categorically apply the Remmer presumption of prejudice stems from our view that not every inappropriate comment by a bailiff to a juror rises to the level of constitutional error. So all they're saying is that not every inappropriate comment will trigger Remmer. So if you have such a procedural type of question about what's going to happen if the jury is deadlocked, even though you're right, it's inappropriate, but it's not going to trigger Remmer. But by inference, anybody who can think for themselves will understand that by inference, that means that if there would be a comment that is not just a procedural comment, it's a comment about the merits of the case, then Remmer would be triggered. So there is nothing in this case at all that says that you have to prove prejudice. It just doesn't exist. And the judge said that it does exist. You see the problem here? And now the judge is requiring the Murdaugh team to prove bias. That's what they have to prove at this hearing. The burden is on them to prove bias. And if they can't, then there's not going to be a new trial granted. And again, it's very difficult for them to be able to prove actual bias. After all, I don't know if these jurors are going to, they have one juror who actually sat in the deliberations. And is that one juror going to say that communication between Becky Hill and her and this juror affected the way that she came to her verdict? I don't know if that juror is going to say that. And if the juror doesn't say that, then case closed. There's no new trial. And that's it. Well, it's not it, because they're going to appeal it, and they're going to say that the burden was unfairly put on the defendant in this case. That's what's going to happen. I mean, if the juror does not say that it affected their verdict, then this is going to certainly be appealed, and then the question is going to be to the Supreme Court, first the Court of Appeals, about whether this judge actually did the right thing. And again, like I said, if you're relying on State versus Green, if this judge is relying on State versus Green, she absolutely misstated the law in State versus Green. That's my opinion about it. And therefore, I think that we may be headed for more trouble now if the new trial isn't granted. So that is it for today. That's what's going on with the Murdaugh trial, and we will see what happens by the evidentiary hearing. All right. If you haven't yet, please subscribe, like the video, and we will see you next time.